I'd like to now call on Maurice Thompson, representing the 1851 Center for Constitutional Law. Welcome to committee.
Thank you, Madam Chairwoman, members of the committee. I don't wish to be redundant. I won't be reading my written testimony, which you have. Many of those points have already been made. You have heard it said that midwifery is currently lawful in Ohio, which is a true statement based upon some research we did. Originally, the sponsors of this bill raised the specter that it was unlawful, and then paraded a bunch of midwife proponents here who said, please liberate us. What those folks were unaware of is that they're already liberated under Ohio law. Midwifery was unlawful at one time. That statute was repealed by the legislature in the 80s, and midwifery has been legal since that time. In the original proponent testimony, you heard it said that perhaps it wasn't legal because somebody was once prosecuted during a home birth experience. However, there has only been one prosecution, and that midwife was prosecuted for use of controlled substances under Ohio's drug laws, not for the unauthorized practice of midwifery. So there's not a single recorded case within the state reflecting a prosecution for the unauthorized practice of midwifery. It's simply not a crime. Rather than liberating midwives or legalizing midwifery, this bill felonizes it. I don't know why it's a felony instead of a misdemeanor or a civil fine. It seems like an extreme case of overcriminalization on par with the legislature felonizing, farming or gardening or procreation, eating or breathing itself. This is one of the most basic functions of life, obviously, birth. It predates any government, and so there's a great deal of hubris in attempting to criminalize something that predates government itself, and as all have mostly acknowledged, tends not to be an area where there's currently a crisis. It would have been helpful if the sponsors had called upon LSC to do a legal analysis of the history of the lawfulness or unlawfulness of midwifery in Ohio, but that hasn't been done. In an attempt to ameliorate the effects of the felonization of midwifery under the amendments and the original version of this bill, the amendments add proposed section 4723.601, and I do want to address that because nobody else has done so today. That section potentially has a great deal of importance if it were written appropriately, intertwined with the remainder of the bill, and the bill were ready for prime time. So that bill states sections 4723.53 to 4723.60, and these are the regulations prohibiting unauthorized practice and the exemptions, do not abridge, change, or limit in any way the right of a parent to deliver the parent's baby where, when, how, and with whom the parents choose, regardless of licensure requirements established in those sections. We agree wholeheartedly with that statement. And the natural reading of that text is that any midwife, licensed or not, should be able to get the permission of the parent, the statement of the parent that they're exercising their rights, at which point no license would be required for assisting in that birth. However, the way the bill is written is still poor, and that's not entirely clear. So, for example, proposed 4723.54b1, which is the section that prohibits the unlawful practice of midwifery and then lays out the exceptions, does not include this as an exception. Instead, it simply says that except as provided in Division B2, no individual shall knowingly practice. So this very important statement in proposed 4723.601 is not intertwined with the remainder of the text. Were this to be an affirmative defense to the unauthorized practice of midwifery, I think we could all go home and be fairly satisfied with the bill mostly as is, even though there is a significant legal barrier, and that is that as written also, this bill violates the Ohio Constitution. It violates the Healthcare Freedom Amendment, which the 1851 Center wrote in 2011 and passed by the voters by a 2/3 majority. Division B of that amendment, this is Section 21 of Article 1 of the Ohio Constitution, states that any new laws, rules, enactments subsequent to 2011 are forbidden if there is a state rule that prohibits the sale of health care or penalizes the sale of health care. The bill, by its own terms, calls natural birth health care. I think that that's a serious debate, whether a normal birth is health care or not. However, the bill itself refers repeatedly to these kinds of births all as health care. So you've heard a lot of disagreement amongst doctors, nurses, midwives today about how the political process here should work. I would submit to you that the voters of Ohio have already made the political choice through our Constitution, our ultimate political document, that no further action should be taken to truncate the healthcare freedoms of parents. And I would also suggest to you that when there is a tie, when the doctors, the nurses, and the midwives and the lawmakers do not agree, that the simplest way to resolve that tie or that impasse is to allow parents to choose. I am one of those parents. I have a 1.5-year-old son who was born at home. I could tell you that the process was exceptionally transparent, and it was very easy to interview multiple midwives. They would take hours just sitting with you at no cost. I will tell you also that the contracts were very clear about transfer issues, about risk factors, about what would happen. I could tell you that the cost was very transparent and also exceptionally affordable. I'll be the one to spill the beans because I've watched all of the testimony so far. Nobody has mentioned dollars. The cost of a midwife, we found, was about $3,000. Cash, payment, that's it. Flat fee. It's not like hiring a lawyer where you're billed on an hourly basis. Thankfully, it was much more wonderful of an experience than that. And it's about $4,000 if you have two midwives, which is a nice option to have, and is what was chosen for my son. The birth was peaceful, no drugs or medication was required whatsoever, and he is perfectly healthy. The process allowed us to be fully informed, much more so than in a hospital birth where you have no idea what the cost is going to be, and you have no idea what the procedures are going to be, particularly as this was in the pandemic era where hospitals were requiring testing for women being rushed in labor at the door. Masking was required even during heavy breathing in the birthing process, and in some hospitals were requiring vaccinations and other sorts of procedures and limitations. So it's very important that this opt-out opportunity exists for folks who do not wish to do that. Finally, a point about the nursing board that hasn't been made yet today, and it is no surprise to me that you just heard somebody from the nurses testify about the importance of forcing expensive insurance mandates on midwives that would break their backs and dramatically increase costs. There is zero chance after those insurance mandates could be passed by the Ohio Nursing Board under this bill that our home birth could cost $3,000 or $4,000. We're probably looking at 3 or 4 times that because all those costs will get passed on to the parents. And that is not surprising because since 1998, the Ohio Board of Nursing has maintained the following in their policy statements on this issue. Quote, "The practice of midwifery by persons other than certified nurse midwives should be prohibited." In other words, this bill farms out and empowers nurses who wish to stamp out midwives over the practice of midwifery by non-nurses. That is exceptionally dangerous. So, what do we do? How do we fix it? It's very simple. You look at what people want here. There are some midwives. Now, as a parent, I did not want a pharmacological medicalized birth. So, most midwives, I can tell you, do not want to engage in a pharmacological medicalized birthing process, which is why they're in the business in the first place. However, there are some midwives who wish to tote around some pharmaceutical drugs that they otherwise may not be able to, or just have them available for emergencies. Well, this is a very simple issue to solve. This does not take the 137 pages that you have before you. This takes basically 1 or 2 sentences that creates a pathway for licensure only for those midwives wishing to use pharmaceutical drugs. You create a licensing process for them, and identify the pharmaceutical drugs. Very simple. Leave the midwives who do not wish to use pharmaceutical drugs completely unmolested by the bill. Secondly, accountability functions are fine. The mandatory informed consent, I can tell you it's already done. As a consumer, we were informed fully. And there's already voluntary contractual arrangements, opportunities to interview, and common law liability for negligence when midwives do make mistakes that they could be sued over. So accountability functions already exist, but there's no problem with the mandatory informed consent provision of the bill. Third, if the sponsors of the bill are serious about protecting parental rights to control who assists with the birth of the children, then the language inserted in proposed section 4723-601, which is the right of parents to deliver with whom the parent chooses, should be made an affirmative defense to the newly created crime of the unauthorized practice of midwifery. Fourth, there are some religious exemptions in the bill. However, those exemptions are not self-executing. In other words, we don't know who those exemptions apply to until somebody gets prosecuted, and then they raise that as a defense for the first time. There needs to be a simple process for individuals to claim a religious exemption. The state already does this. It does it for vaccination requirements in public schools now. Parents can simply submit a one-page form as a conscientious objector, and it's a self-executing form where you claim the religious exemption. So that if you're going to have religious exemptions in any bill, you have to do that here too. And then five, finally, because of the vast disagreements here, it's best simply to allow parents to decide. There are lots of different opinions, lots of different choices, faux experts on both sides with competing data. It's best just to let parents who have the greatest stake in the matter sort the issue out and not assume that they are children because, of course, they're about to have children. They're not the children of the legislature. They're not the children of the doctors. They're able to make adult decisions because they are adults and they are parents. Happy to take any questions now or subsequent to the hearing.
Thank you very much for your testimony today. Are there any questions for the witness? Seeing none, thank you very much.